In our second lecture here on truthfulness, we're going to deal with principles of confidentiality. We want to first start by making a clear connection in the Nursing Code of Ethics in Provision 3. First, the privacy is defined as the right to control access to, disclosure or non-disclosure of, and information pertaining to oneself, and to control the circumstances, timing, and extent to which information may be disclosed. So, connected specifically in the nursing profession, they have a duty to maintain the confidentiality of all patient information, both personal and clinical, in the work setting, and off duty in all venues, including social media or any of the other means of communication. So, within this provision and code, we're going to detail, I think, a few more aspects of this, talking about types of secrets, and certainly talking about the role of social media and different forms of communication. So your book notes there are three types of obligatory secrets: the natural secret, the promise secret, and the professional secret. Again, I think there's probably overlap with some of these, but the natural secret is so named because the information involved is by its nature harmful if revealed. So in that case, it might be a particular diagnosis or other pieces of information. Promise secret is knowledge that has been that the healthcare provider has promised to conceal. And again, given the contractual obligation to the patient, there has to be a lot of overriding considerations for that to be broken. We'll talk a little bit about some of those. The professional secret is knowledge that, if revealed, will harm not only the professional's client, the patient, but will also do serious harm to the profession and to the society that depends on that profession for important services. So here you can see this is one of the most important, and certainly the importance of the professional secret is seen by contemplating the consequences if a patient's lack of faith um, in the confidentiality of their dealings with the healthcare system is violated. So, unless forbidden by the patient, a healthcare professional has a right to consult other healthcare professionals in an effort to help the patient. But aside from that, we're going to see that confidentiality really needs to be upheld. There's a section of exceptions that your book will go through in terms of statute laws, legal precedents, court decisions, and I don't think we're going to get into much detail there. I think that one of the constant reminders is that each state has its own laws and local statutes that must be consulted. And while we've talked about the overlap of ethics and law, I think for the most part, a lot of the particulars in these cases and laws need to be kind of understood within context. I think for me, and it may be because I'm an educator, the one area that kind of jumps out at me is the child abuse laws. Um, and I think we've had a much higher increase in which the notion of a mandated reporter, which we talked about in the last lecture, is really important to know and to acknowledge. There are exceptions, as we were talking about the notion of a mandated reporter, in revealing information about cases of children and adolescents. You can see that in the past, information was reported directly to parents on the health of their children. But there has been an increasing recognition that sometimes confidentiality, particularly around issues of substance abuse or contraception, is to be in place. And I think the ethical concern here is that, again, we're able to build trust and continued treatment. Um, and if that feels violated, we want to kind of recognize that. There are exceptions, obviously, in treating children and adolescents. They mention here sexually transmitted diseases, but also sterilization and things like that. So again, we'll kind of see how that balance act works. Media publicity and confidentiality. I think this was contained in a bit in your provision 3 of the Code of Ethics. But if there's particularly a situation where a public figure might be hospitalized, you could see where there's a lot of desire to for the media to kind of gain that information. But even on a more basic level, sharing pictures or sharing information, even if it's not connected with a name, whether through Facebook or Twitter or other means such as that, really needs to be carefully um, controlled. I just basically think that information should not be shared in the case that one was able to kind of put together who that person was and what the condition was. Hospital records, research, and confidentiality. The patient has to give permission for those involved in his direct care to see any of those records. So it just also recognizes that not only the healthcare provider, but really healthcare administration needs to be very careful about how records are stored and shared. There were 2 points that I thought were helpful on page 127 around particular consent of records. And these two things that should be kept in mind is only summary data with no identification should be used in publishing the research. And secondly, that the number of people who see the record itself should be kept to a minimum. And both of these provisions are attempting to help protect confidentiality and to remind people of its importance. There are exceptions that can arise from unusual relationships. These may happen with family and military personnel who owe particular loyalty to their employer as well as their patient. And as long as all understand that they are not fully protected by confidentiality, there's no ethical issue. But if there's a situation where you are providing information to a third party, whether that's a government or maybe a workplace, that the patient is not aware that you're sharing that information, that would be a violation of confidentiality. And there are some few exceptions due to proportionality. Ordinarily, a professional will not be allowed to reveal information merely for the good of a third party, even if that third party happens to be a patient. But there has to be larger considerations around wider public good. I think the biggest example that your book highlights is really cases of HIV, in which not sharing that information um, of an HIV carrier can lead to an increase in infection and spread of the disease. Familial exceptions, compassion for the spouse and the family does not qualify for breaching confidentiality between patient and doctor. So again, even if there's a particular venereal disease that a husband or wife is carrying, you cannot reveal that to the spouse without the patient's um, knowledge of that, even if you just feel bad for them. So again, last three categories and talk about these third parties, which we've mentioned, government, workplace, but also insurance companies. And this is part of the Affordable Health Care Act, but there is a little bit of protection around what they used to call pre-existing conditions. But it's very important that information is not shared with insurance companies without the patient's permission. Um, Patients expect confidentiality, and a violation of it will certainly hurt society, yet keeping the matter secret may also harm society. And this are those situations where this becomes a dilemma for the physician. And again, you could see the example particularly of having a patient that's HIV positive. So I think that that gives us some general framework of the importance of confidentiality. And in our last lecture, we're actually just going to jump ahead to part of Chapter 6 and talking about the role of ethics panels.